Hello friends, my name is Dr. Jigisha Singh and in this video I am going to discuss cases on capacity to contract, doctrine of privity of contract, exception charge, consideration, charitable subscriptions. The first case relates to capacity to contract. The name of the case is Rani versus Prem Adib, I.L.R. 1949, Bombay 215. Well, the facts of the case are: the plaintiff Rani, a minor, was promised a role in a film by the defendant Prem Adib with a salary of Rs 9,500 per year. Her father signed the agreement on her behalf. When the producer gave the role to another actress, Rani sued for breach of contract. The Bombay High Court dismissed the suit, reinforcing that minors are incompetent to contract for personal service in India. Well, the Bombay High Court held that a contract of service employment involving a minor is void and unenforceable, regardless of whether it was made by the minor or their guardian for the minor's benefit. A minor cannot enter into a contract directly. Any such agreement is void ab initio, void from the very beginning under Section 11 of the Indian Contract Act 1872. Even if a father guardian enters into a contract on behalf of the minor, it is void if there is no valid consideration. In this case, the minor's promise to act in a film was not legally enforceable and thus could not serve as consideration for the producer's promise to pay. The court, distinguishing between contracts of service or contracts of apprenticeship, while apprenticeship or marriage contracts might be enforceable if made by a guardian for a minor's benefit, a standard service contract for a minor to work as an artist is not. Because the contract was void, neither the minor girl nor her father could sue the film producer for damages when he replaced her with another actress. The next case is also on capacity to contract. The name of the case is Gokeda, Lateharao versus Viswanadhan, Bhimayya, I.L.R. 1956, Andhra Pradesh 182. Established that a contract with the minor is void ab initio and minor cannot be compelled to repay money advanced, even if he or she misrepresented his or her age or the agreement was void. Even Section 65 of the Indian Contract Act did not apply. The facts of the case are: the plaintiff appellant sued the defendant, minor respondent, for money due on two promissory notes executed in 1947. The defendant claimed that he was a minor at the time of execution. The lower appellate court found that the defendant was indeed a minor but had fraudulently misrepresented his age and received full consideration. The lower appellate court decreed the suit applying Section 65 of the Indian Contract Act for restitution of the benefit received by the minor. Issues were whether a contract entered into by a minor is enforceable if there is fraudulent misrepresentation of age, whether Section 65 of the Indian Contract Act restitution of benefit under the void contract applies to minor's contract, whether equitable relief can be granted to the lender to recover money from a minor. Now, the decision of the Andhra Pradesh High Court was: the High Court set aside the lower appellate court's decree and allowed the appeal. A contract with a minor is a nullity, therefore it cannot be enforced. Section 65 of the Indian Contract Act cannot be invoked because it presupposes a contract between competent parties. Fraudulent misrepresentation of age by a minor does not make the contract enforceable. Equitable restitution under Specific Relief Act 1877, then Section 39 and 41, applies when a minor is a plaintiff seeking to cancel a document, but not when minor is a defendant sued to enforce a void contract. The court held that the lender cannot recover money advanced under promissory notes executed by a minor, reinforcing the total protection of minors from contractual obligations. The next case is MC Chacko versus State Bank of Travancore. Citation is I.L.R. 1970, Supreme Court 504. The first party is the defendant, second party is the plaintiff. Case pertains to doctrine of privity of contract, more particularly pertains to exception of charge. Now, the question involved was whether on the facts of the case there was a charge created or not. The test for the charge is we have to find out as to what was the dominant object of the person creating the charge. If the dominant object was to benefit and protect the interest of the third person, it amounts to charge. However, where object is something else and third person is merely referred to in the agreement, it is not charge. The facts of the case are: D was the manager of other bank. This bank was having overdraft facility with plaintiff bank. The time of overdraft bank asked for some guarantee so that loan of P is secured. Plaintiff had no faith on D. Defendant, for better business, requested his father to issue a letter guaranteeing in favor of plaintiff. By virtue of this letter, loan was granted. After some time, father of manager D decided to gift the property among his sons. Gift deed was in writing and decided share was given to the sons and major portion of the property was retained by the father. Gift deed. The father wanted to get rid of the personal liability created by the letter of guarantee, so he included a condition in the gift deed that in case of non-payment, D and his share of property will be liable and father and his share of property will not be liable. Father had actually clarified his liability vis-a-vis himself and his sons. Son got his share and became the owner. The bank of D manager could not repay the loan. P filed a suit instead of enforcing a loan against the manager personally. Bank came to know about the gift deed and therefore P wanted to enforce the unsecured loan against the property gifted. Since bank was not a party to contract, it could not be enforced. It could be enforced only it falls under the exception of charge. D argued the dominant object was not to convert loan into secured or unsecured loan but to classify the liability in reference of bank past incident. Parties never intended to create a charge. It was held that no charge was created over the property. The state bank had no right to enforce the gift deed and limitation period had expired under the letter of guarantee. Now we move on to the next case. The next case is Venkata Chinnaya Rao versus Venkataramaya Garu, I.L.R. 4 Mad 1371881. It is a landmark Indian legal case that established the principle that consideration for a contract can move from a third party, a stranger, to consideration rather than just promisee. The case overview is the parties. The dispute was between Venkata Chinnaya, the plaintiff appellant, who was the sister of the elderly lady, and Venkataramaya, the defendant respondent, who was the daughter of the same lady. As per the facts of the case, an elderly woman gifted her estate to her daughter Ramaya through a registered deed. A condition of this gift was that Ramaya must pay an annual annuity of Rs 653 to her aunt Chinnaya. Ramaya agreed to this and entered into a separate agreement with Chinnaya to pay the sum. After the mother died, Ramaya stopped the payments, arguing that Chinnaya had not provided any consideration, payment, or service in return of the promise, and therefore the contract was unenforceable. The Madras High Court ruled in favor of Venkata Chinnaya. The court's reasoning were based on several key points. Under Section 2D of the Indian Contract Act 1872, consideration may move from the promisee or any other person. This differs from English law, where consideration must move only from the promisee. The gift from the mother to the daughter and the daughter's promise to the aunt was considered parts of the single transaction. The mother providing the property was sufficient consideration for the defendant's for the daughter's promise to the aunt. Even though Chinnaya was a stranger to consideration, she was a party to the agreement with Ramaya and was therefore entitled to sue to enforce it. This case is primary authority used in Indian law to distinguish between a stranger to consideration who can sue and a stranger to a contract who generally cannot sue, though there are exceptions. The next case is Kedarnath Bhattacharjee versus Gorie Mohamed, I.L.R. 14 Cal 64 1887. The first party is the plaintiff, the second party is the defendant. This is a landmark judgment in Indian contract law that established the enforceability of charitable subscriptions when the promisee had acted upon that promise and incurred a liability. The facts of the case are: the plaintiff Kedarnath Bhattacharjee was a municipal commissioner of Howrah and a trustee for the Howrah Town Hall Fund. The commissioners planned to build a town hall providing enough funds were raised via public subscriptions. The defendant Gorie Mohamed voluntarily subscribed his name in the subscription book for Rs 100 for the construction of the hall. On the faith of these subscriptions, the commissioners entered into legally binding contract with the contractor to build the hall. The project's cost eventually rose from 26,000 to 40,000 as plans were expanded. When the defendant refused to pay his Rs 100, the plaintiff sued him for the recovery in Howrah Court of Small Causes. The lower court initially dismissed the suit, prompting an appeal to the Calcutta High Court. The core issues were whether the defendant's promise to pay Rs 100 constituted a valid and enforceable contract under the Indian Contract Act 1872, whether there was sufficient legal consideration for the promise given that the defendant received no direct personal benefit. The decision of the High Court ruled in favor of the plaintiff, holding that Gorie Mohamed was legally bound to pay the subscribed amount. The court held that while a mere charitable promise is generally unenforceable for lack of consideration, this case was different. By subscribing, the defendant effectively said, in consideration of your agreeing to enter into a contract to erect this building, I undertake to supply the money. Now, once the trustee acted on that promise and incurred a financial liability entering into a contract with the builder, the promise became irrevocable. The court dismissed the defendant's plea that his lack of education prevented him from understanding the commitment, noting he was fully aware of the project's purpose when he signed. The court ordered the defendant to pay ₹100 plus the plaintiff's litigation. With this, I conclude. In the next lecture, I will be discussing about frustration of contracts.